Alrighty. Good morning, everyone. My name is Katie Lewis. I know you are used to seeing Joanne Jarvie. Unfortunately, she had a conflict this morning, so I am going to be our host for today. Thank you very much for joining us for the download. Excited to have Shreya here today to give us some policy updates. I'm just going to run through our quick opening slides that you all, if you've been to the download before, have seen before. And as you know, our format is pretty informal. Please feel free to come off mute to ask questions, use the chat, and we will answer your questions to the best of our ability. And if we can't answer them on the call, we will definitely take your question and follow up with you after the call. So with that, let's get started. If my computer will work for us. So this is just a very blurry picture of me. Sorry about that. Just a quick last minute change this morning, but I am the Director of Marketing Operations and External Communications here at MiHIN. So I'm kind of the behind the scenes that helps host these. And then a little bit about MiHIN. You all, I'm sure, are very familiar, but just in case we have anyone new here, MiHIN is a nonprofit organization that provides tech and services to connect disparate sectors to securely, legally, technically, and privately share health information. I won't read all of the slide, but if you have any questions about who MiHIN is or what MiHIN does, please feel free, again, to come off mute, ask questions, use the chat, or reach out to us after the webinar as well. And with that, like I said, I'll keep my intro short and sweet so we can really get to the topic on hand today, which is navigating the changing health IT landscape. There have been a lot of public policy updates this year already. And so we have asked Shreya, who is our Chief Policy and Privacy Officer, to join us today to kind of give a summary of all of these, since there is a lot of information that comes along with them, and to let all of us know how they might affect you and your organization specifically. So without further ado, I will turn it over to Shreya. I'm going to stop sharing my screen and she'll pull up her slides.
All right. Good morning, everyone. As Katie mentioned, this is Shreya Patel. I'm the Chief Policy and Privacy Officer with MiHIN. And today I'm going to be covering these public policy updates that we've seen over the past few months and that may impact many of you. So there are going to be three main topics that we're going to be covering today. The first one is going to relate to significant updates to 42 CFR Part 2, or the regulation that governs the confidentiality of substance use disorder. The second topic is going to relate to the CMS interoperability rule, which governs three new patient access. So those are going to be the provider access API, prior authorization, and payer-to-payer exchange. And then the last topic that we're going to cover is going to be a few updates that we've seen to the Trusted Exchange Framework and Common Agreement known as TEFCA. And this is really going to help move us forward in the space of national interoperability. So the first update that we're going to start with today is going to be the Part 2 updates. And there are really three federal agencies that kind of coordinated for the update of 42 CFR Part 2. First, we have the Department of Health and Human Services, or HHS, which the next two agencies kind of fall within as sub-agencies. Second, we have SAMHSA, or the Substance Abuse and Mental Health Services Administration, which is really going to be the one responsible for oversight of Part 2 facilities and the rules that govern them. So they really led a lot of this effort. And then third, you're going to have the Office of Civil Rights, which is going to be the entity responsible for the enforcement of Part 2 regulations. So in the proposed rule, SAMHSA discusses the rationale surrounding this final rule change, and they stated that when 42 CFR Part 2 was released back in the 80s, it was done so prior to HIPAA and prior to an electronic healthcare records landscape. And for that reason, they didn't really contemplate that any organization would actually be subject to both regulations simultaneously. Due to the fact that many organizations today are subject to both regulations, particularly if they are larger healthcare systems that has a Part 2 facility within it. And due to the fact that we have kind of moved towards that space where health records are predominantly done electronically and care coordination is being emphasized more and more year after year, there has been this kind of ongoing confusion surrounding what compliance looks like today. And as many of you know, this has kind of subsequently resulted in barriers to care coordination and siloed Part 2 entities when that might not have been the initial intent. So what you're going to see a lot in this update to Part 2 is that it really looks to resolve this disconnect by aligning Part 2 with HIPAA and with the CARES Act. And the reason that the CARES Act is really coming into play here is when the rule was actually proposed a few years ago, it was done so in the early stages of COVID, where care coordination was a huge topic of discussion and conversation. And then another theme that you're also going to see as we go through the next few slides is you're really going to see an effort to make things as easy as it can be to share information while still safeguarding patient interests. All right, so under 42 CFR Part 2, consent is required prior to sharing PHI from a Part 2 facility. And the main question that we oftentimes receive on this rule change, as well as when the proposed rule came out, is if consent is still going to be required. The short answer is yes, it is going to be required, but the final rule change really makes it easier for patients to share information. So first, the consent requirements for Part 2 entities are going to be aligned with HIPAA authorization requirements, which means that the only required areas in the consent form is going to be the identity of the discloser or the Part 2 facility itself, the recipient, which can also be a general class of people or organizations. It doesn't need to be super specific. The description of the information to be disclosed, which can be as general as stating for treatment payment and healthcare operation purposes, the right to revoke consent for disclosures made after the revocation occurs. And by that, I mean that it's only going to be forward-facing and nothing's going to be in retrospect. And then the fifth thing will be the expiration of the consent as well. Now, there are a few noteworthy things here that are going to help to decrease barriers around consent. And these are going to be some of the things that I listed, but also individuals can sign just one single consent form and have that be effective until they revoke consent. So it can kind of be used continuously instead of having to sign a new form at every visit or every year. Second, as I mentioned, a class of people or a general description is going to be sufficient for the form. It doesn't need to be each entity or provider exactly. So you can say something like, share with my HIE, share with my primary care doctor, or even a certain agency for benefits determinations, and that is going to be allowable, whereas before there was kind of a question mark on if that would be acceptable. And then lastly, they do allow for, but they don't require more granular consent. So you can say something like, I just consent to share my healthcare information for all treatment payment and healthcare operations purposes. And that is going to be something that is allowable as well.
Shreya, can I pause you for just 1 second? We had a chat come in asking if you could please clarify who Part 2 entities are.
So Part 2 entities are federally defined entities, and I believe that there is two parts to the definition. The first one is that their predominant purpose is to aid in the treatment of substance abuse disorder, and then the second component is that they receive federal funding. It's kind of interesting because I think for our Part 2 facilities, even though they're federally defined, I don't think that there is like a comprehensive list. And for the most part, a lot of those are self-declared. So, you know, if there's a question on it, I'm happy to provide additional guidance on it. I think that there are fact sheets that SAMHSA has. But for the most part, these facilities are going to be kind of like self-declared entities as Part 2 facilities. And they're kind of stating that they are subject to the rules. It's not going to be all entities that handle behavioral health information or may help with addiction treatment. That is going to have to be their primary purpose, and there is going to be that second component of the funding. Any other questions in the chat, Katie, that you want me to handle before we move on?
There are quite a few that might be coming in. So do you want to address them now, or do you want to kind of wait for questions till the end? What is easiest for you, do you think?
If there are many, we can wait till the end, but if it's on the same topic, I'm happy to take them now. Just let me know what it's looking like.
Okay. So there's one saying, is this to mean a primary care office or clinic can get a consent signed and there is no expiration date?
Well, these consent forms are going to need to come from the Part 2 facility itself because it needs to come from the sender of the Part 2 information. And they're going to have additional obligations that we're going to go through to educate patients. So it can't really come from any primary care provider. It's going to have to come from the Part 2 facility.
Great. And then directly federally funded only or broad enough to include contracted PIHPs?
That one you might need to circle back just with your internal legal team on, just because there are kind of different interpretations when it comes to that. And there's some guidance maybe specific to a particular type of organization. So, I might not be the expert on that. So I would just encourage you to probably check in with your legal team on that. But like I said, I can always provide those high-level guidance documents that we've seen from SAMHSA that delve into some of those details.
Great. And would FQHC be included in this?
Yeah, kind of same response for that one.
Yep. Perfect. All right. I think that catches us up. Thank you for answering those.
Okay. Yep, that sounds good. All right, so when it comes to redisclosure requirements, this is going to be another instance where we're going to see Part 2 aligning with HIPAA, as I mentioned previously, because any entity that receives information with the appropriate consent for treatment, payment, and healthcare operations can redisclose for any manner permitted under the HIPAA privacy rule. And there's just going to be one small exception for legal proceedings, which we're going to dive into later. We're even going to see that this redisclosure is going to be allowed for things like payment in between contractors and subcontractors, which is something that had a lot of confusion surrounding it initially prior to this rule change. So they're really trying to clear up some of those outstanding questions that had existed for decades. As many of you may be aware, an accounting of disclosures is basically an accounting that entities must provide to individuals upon a request of each instance in which their information was disclosed to another provider or another organization. And under the new rule, Part 2 entities are going to need to provide these accountings for up to 3 years prior to the date of request. So this one's going to be more of an administrative rule for the Part 2 entities themselves, as well as something that, might be good to know for everyone at large. So there are a few restrictions and permissions on disclosures that come up in the rule. And the first one is that if Part 2 entities are not able to limit a patient from restricting the use of their records for treatment, payment, and healthcare operations, which means that Part 2 entities can't restrict a patient in what they choose to allow or restrict on that consent form. So while they're going to make it easier for those patients that want to share their information for care coordination, they can't stop them from using that consent form in order to restrict in a certain manner moving forward. Second, and similar to HIPAA, Part 2 entities aren't going to be able to limit restrictions to withhold information from the payer if the patient self-paid for services. Third, Part 2 entities can't limit a covered entity's choice to obtain the consent to use or disclose records for TPO, and that's really going to be done to prevent information from being siloed in the Part 2 facility by the Part 2 facility. And then last, there is an ability to report Part 2 information to public health authorities as long as the information is de-identified, which is going to be similar to what we see on the physical health side in certain instances. Obviously, identifiable health information is able to be shared with public health authorities when it is compelled by federal and state law. That's something that's always going to be allowable, but they really are expanding the ability to use some of that Part 2 information if it's de-identified in the same ways that we see those allowances in HIPAA for physical health information. So I did mention a couple slides ago that redisclosure is required for any allowance granted in the HIPAA privacy rule, aside from just one small exception for legal proceedings. And that's what's really being captured on this slide. Entities are not going to be able to submit testimony with Part 2 information within it without a court order or unless the patient opens the door for this information to be used or introduces it themselves in some other manner. And then when it comes to the court orders themselves, those are not going to be readily granted unless the Part 2 information is required to prevent a serious bodily injury, to prosecute the patient for a serious crime, which is going to be a very limited list, or if the patient's already opened the door for that to be used, as I mentioned. In addition, patients of Part 2 facilities who obtain their own information through patient access avenues and third-party mobile apps can't have that information used in legal proceedings as well. So again, we're going to see some of those balancing of interests and making sure that individuals have their information protected in this context. So sometimes an investigative agency may have to investigate a Part 2 facility in the normal course of their work, and it is possible that they may inadvertently come across a Part 2 record. This is not going to be an instance in which the investigative agency will be subject to a civil or criminal penalty. However, they have to apply for a court order after they discover the information, just in order for this to still hold true. This is not actually something that's going to be super applicable for most of our participant organizations, but there was a fair amount of space and language dedicated to this topic in the rule. So I just chose to include this in case some of you were going back to the original text and kind of confused as to what this discussion was. This is just kind of a quick summary of what they're trying to explain and clarify. So as mentioned, this rule showed a large push to align HIPAA and Part 2 regulations with each other. And this is something that you're going to see by SAMHSA all throughout the rule. So you see it as they kind of work to align their definitions and the terminology in the regulation with HIPAA. You're going to see it as they make exceptions for sharing with health plans when individuals lack capacity, which is very similar to the way that things are handled under HIPAA. You're going to see it as they make allowances for de-identified information to be used for research purposes, as they allow psychotherapy notes to be used with the consent of the provider, of course, and then also as they kind of align some security provisions with HIPAA, and that's going to be in terms of things like updates to internal policies and procedures, as well as the Part 2 responsibilities when it comes to breach notification requirements. And then one other noteworthy alignment is when Part 2 information becomes part of a designated record set for another covered entity, it's going to be considered PHI and subject to HIPAA moving forward. So that's also something that's going to be good to know in terms of sharing information across the healthcare landscape. Now, because this rule change is going to make it much, much easier for information to be shared, SAMHSA determined that it needed to kind of balance this against safeguarding individual rights and their ability to protect their Part 2 information. So in this vein, they kind of built out the requirements for the notice of privacy practice. And for those of you who aren't as familiar, a notice of privacy practice is a notice given by covered entities to individuals so they're able to understand when and how their information can be used. It also outlines their rights under HIPAA and other regulations as applicable, and it kind of provides certain avenues for reporting complaints to that entity as well. So while Part 2 providers were always required to provide this to individuals, there are now going to be even more detailed requirements on the information that a Part 2 provider must provide to their patients. And that's going to include things like detailed summaries of the laws that protect them, as well as exceptions to when they may not be protected. It's going to include the uses and disclosures that are going to be allowed with that consent form, what may require additional consents beyond that form, such as with marketing, what's going to be restricted or not allowed. And so an example of that might be the legal proceedings exception that I called out. It's going to outline individual rights related to inspecting their own records and their accounting of disclosure rights, as well as restricting on self-pay. And then in addition to that, it's also going to outline what the responsibilities of the Part 2 program is in the instance of a breach. And kind of walk through the process of reporting those complaints as well. So this section might not be applicable to all of you who aren't Part 2 entities, but for those of you who are, this section is definitely worth a deep dive just to ensure that you're meeting all the requirements of the Notice of Privacy Practice. It's not going to be enough just to update that consent form and make it a little more broad and allow for it to be continuous. You also have to make sure that all of the other sections of the rule are also in compliance. And then I'm not going to go through each of these, but the final rule does touch on a variety of other topics related to restrictions on retaliations and waivers, how qualified service organization agreements are still able to be leveraged, although not as necessary. It goes into minor patients as well as audits and evaluations. So if any of those are kind of piquing your interest, I would say it might be worth it to go back in and do a deeper dive into the rule just because it does cover quite a bit of content. So I'll just pause here just to see if there are any other questions, Katie, in the chat, or anything you want me to address before I get into the CMS interoperability rule.
I don't see anything in the chat right now, but does anybody have any questions before we keep going? Feel free to come off mute. Alrighty, looks like we can keep going.
All right, sounds good. So we're now going to pivot and change topics from 42 CFR Part 2 to the CMS interoperability rule. So in the same way that the last interoperability rule that came out of CMS was dubbed the patient access rule, this new rule is being dubbed the prior authorization rule, but in actuality, there are going to be three main topics that are covered in the rule. The first one is going to be prior authorization. The second one is going to be a provider access API. And then the third one is going to be payer-to-payer exchange. And this was kind of posed as an expansion to the patient access rule from CMS, but I see this more as an expansion to the use of FHIR, or the Fast Healthcare Interoperability Resource, and the way that FHIR is used in the payer space to just bolster more efficient uniform information sharing. So there's a lot of exciting things that are happening in this rule, but just for your awareness, because there is so much content here, the compliance period for this is not going to go into effect until 2027. And I don't think I mentioned it, but for Part 2, I believe that it's not going to go into place for another 2 years in 2026. So let's just start with the first topic of prior authorization and what is required. So this new rule requires payers to add to their existing FHIR infrastructure and build an entirely new API which integrates into their existing EHR and is able to select the appropriate pieces of information needed for a prior authorization request in an automated manner in order to reduce administrative burden. So why was this rule proposed and finalized? As I mentioned, this rule is really an attempt to alleviate the administrative burden surrounding prior authorization requests and automate the process as it functions today. The intent is also so that it can free up resources and save time so that the requests can be processed more quickly, so individuals aren't waiting on them. So which payers are required to comply? This is not going to apply to all payers initially. In the same way that the patient access rule started with a smaller set of listed payers, this rule is going to kind of do the same, and then perhaps with the intent to expand to more as time goes on. I will say, though, we have seen other payers that might not be in this list still choose to comply with some of these payer rules just as best practices and just to promote interoperability. So that is something that's good to know just in general. So while the payers are going to be responsible for setting up the new integrated API to automate the prior authorization process, they're also going to be required to make certain prior authorization information available to patients in the existing patient access API. So this is going to include information on all requests and decisions, the status of those decisions, the date a prior authorization was approved or denied, if it was approved, the date that the authorization would end, items and services that were approved, the quantity used to date, and any materials that the patient's provider may have provided to the payer to support that decision. On the flip side, if it's denied, they're also going to need to include a specific reason for that denial, but obviously none of the categories that are required for the approved ones. And then this second slide is really going to get into the requirements of the API itself, which will be called the Prior Authorization Requirements Document and Decision API, or the PARDI API. So I mentioned a few of the requirements on the initial slide, and those were ones such as the fact that payers must be able to automate the process of determining when a prior authorization is required. They must allow providers to query the payer's party API to find the requirements for the prior authorization. They must support that automated approach to compile the required data elements for either an approval or denial as well. And then in addition to those ones I had mentioned previously, they also have to respond to the requests within 72 hours, which is actually a little bit longer than what they had in the proposed rule, and they kind of lengthened that after they received some feedback. And then they're also going to require payers to report metrics surrounding the prior authorization processes and the use of the party API just for transparency purposes and to see how well this is working. And then a few other items that are good to know is that providers will have access to the same information about requests and decisions as the patients, and that's going to be through the Provider Access API that I'm about to talk about in just a couple of slides here. In addition, the prior authorization process proposed will only apply to items and services. This time, it's not going to apply to drugs of any type. And then party information is going to be required to stay in the patient and provider access APIs for at least 1 year so that they can always refer back to those decisions and see maybe why those were approved or denied. And then lastly, similar to the patient access rule, covered entities and business associates can provide information on the privacy and security of party information because this information would be getting sent to the third-party mobile applications if it's being pushed to the patient access API. But again, similar to the patient access rule, the efforts really have to stop at education, and they have to accept patient requests to send that information to apps of their choosing. So that's really just something that we're seeing reiterated. I did see a few chats pop up. Katie, do you want me to cover those before I move on to the Provider Access API?
Yeah, how about we do that? I see the one, are there standardized reasons for a PA denial?
Yes, yep. So they do go into some of those in the final rule as well. And so in the kind of like name of efficiency and to make sure that this process is kind of automated, I do think that there are going to be some standard responses for the payer in order to get those responses back to the providers that might be requesting them a bit more quickly. And so that's kind of where we'll see some of those standard reasons for denial. I can see if I can pull those from the rule, and when we send out the deck, we can also include that information.
Great, and I think the others were just more comments about this being really helpful, unless I missed any.
Okay.
But I think that's it.
Okay, great.
Moving on.
Perfect. So now we'll move on to provider access. This one is a bit more straightforward, and in essence, this part of the rule would require payers to make available the same exact information that's available to patients in the Patient Access API available to providers of those patients through this new FHIR API. The one very important aspect of this rule is that CMS has made it clear that providers are not able to receive information or request information on patients if they are not actively caring for that individual or not otherwise a part of that patient's active care team. So CMS has put forth as a suggestion that payers should leverage existing patient and provider attribution frameworks. And these are going to be frameworks that are very, very similar to what we already have here at MiHIN through our active care relationship service. So HINs such as us should absolutely be leveraged in this instance, as CMS suggests, just because we already have the existing infrastructure to determine who is on a patient's active care team and help to determine when it's going to be appropriate for providers to be making those requests and when it's appropriate to actually share this information. The reason that I'm bringing this up is, one, it's a key nuance of this portion of the rule, but also because it directly relates to the health information network space. So why was this rule proposed and finalized? So it is very clear that providers play an integral role in the prior authorization process. just because they are typically going to be the ones that are requesting items and services or providing information relevant to a prior authorization request being approved by payers. And so for this reason, having the API where they can have access to the same information as the payers and as the patients is going to make sense and foster an additional kind of provider and payer information sharing pipeline as well. Furthermore, it's probably going to bolster care coordination at large between providers and patients, just so providers are able to have access to the same information as their patients, so that there's no fragmentation in the records and they're able to give the most comprehensive and complete care that they can. And as always, there are going to be a few requirements when it comes to what should be included in the Provider Access API. This is going to include claims and encounter information, the data elements in the US CDI v1, and then all of the information that the payer maintains, as well as newly this prior authorization information for the past year. If this sounds familiar, it's because, again, it's that same exact set of information that the patients get through the Patient Access API. So if you've been hearing a lot about that over the past few years, this is going to be the same exact set. The only addition is going to be that prior authorization information as well. Payers are also going to be responsible for providing educational materials to both patients and providers. So in terms of the educational materials for the patients, they are going to be required to outline the benefits of a Provider Access API, information on the ability for the patient to opt out of having their information shared via this API. And then all of this information is going to need to be provided at a easily digestible or low reading level, and it's going to need to be publicly available for patients as well. On the educational materials for the providers on the Provider Access API, they are going to need to provide information related to requesting information on behalf of their patients, how to use the attribution process to determine if they can even make that request, and then some more general resources and some of the more technical aspects. This is going to need to be available through the payer's website again and easily available, but they don't really get into reading level for this one. And then there will be a few differences between the provider and patient APIs. So just as one example, where patients kind of use, third-party mobile applications to request their information, providers are going to be using their existing EHRs to request that information, or at least that's the way that CMS is contemplating that working today. Providers are also not going to be able to have certain payment information shared in the Provider Access API. And if the provider doesn't have the appropriate data sharing agreement in place to receive information from the payer, that may be a basis that the payer may not be required to provide that patient information to the provider. But that's going to probably not be at play so much in Michigan when we do have the health information network that connects so many of these entities. And we are all bound through the same kind of legal chain of trust. So providers that are using the payer's party to make prior authorization requests in 2027, when this all goes into effect, will be able to attest yes to certain MIPS requirements when that time comes, and that could really help to promote its score and increase CMS dollars coming to it. So this is also something to be cognizant of if you are a provider and you are intending to kind of leverage these new technologies. And then I'll just pause here. Katie, did we get any questions on the Provider Access API before I move on to payer exchange?
Yeah, it does look like we had two questions come in. Eric had asked, he said, I believe the new CMS rule allows flexibility to any US CDI version supported by the ONC, correct?
Yeah, I think that you're absolutely right on that. I just called out V1 just because that was the number one requirement, or like when I say number one, I guess I mean the minimum requirement of what they need to provide. But CMS is always encouraging organizations to adopt these more recent versions as they're constantly being updated, and they contain very valuable data fields that would definitely we want to be shared if they're available.
And then Carrie was asking, would care that spans across multiple health systems be shared on the Provider Access API?
I'm sorry, could you repeat that? I just missed the first part of it.
Yep. Would care that spans across multiple health systems be shared on the Provider Access API?
Yes, and the only kind of caveat to that I would say, like, I think the short answer is yes, but the only caveat to that would be this is going to be a payer obligation, and they're only going to be required to share information that they're maintaining in their systems. So if the payer does have access to all of the care that's spanning across the healthcare landscape, including multiple different health systems, that is going to be pushed to the Provider Access API, yes. There's not going to be any restrictions in terms of that.
Great. And then we just had another one come in. Will payers translate prior auth requests from provider organizations that are using 278 prior auth integration into their FHIR API?
Oh, I am not sure on this one. I do not know off the top of my head, but I can look it up and follow up with the individual who asked that question.
Great, thanks.
Okay, great. Anything else, Katie?
Nope, looks like we are good to continue on.
Okay, great. So lastly, we're going to move on to payer-to-payer exchange, which is an instance in which CMS put forth a requirement for existing payers to send a patient's information to a new or a concurrent payer for 5 years after the patient leaves the plan or on an ongoing basis as needed for concurrent coverage. So why was this rule proposed and finalized? So the purpose of payer-to-payer exchange, as stated by CMS, is actually to create a longitudinal record that follows patients as they travel across the healthcare landscape from payer to payer, and it's meant to prevent delays when an individual switches plans. So in terms of requirements, payers must make that same data class available as the Patient Access API, which again is going to include that USCDI V1 or future versions, adjudicated claims and encounter information, and of course those prior authorization decisions. And then in terms of timeline, they're only required to have, as I mentioned, the last 5 years of record from the date of request or from when the individual left the plan. For multiple patients data, the payers are able to use FHIR bulk data access. So this is going to be a little bit different in terms of the FHIR-based exchange that's going to be leveraged here. So there are some more requirements listed on the slide, and the one that we really wanted to call out is that CMS wants wants payers to allow patients to opt in to this type of data sharing as opposed to allowing it to happen automatically when notified of a change. We were opposed to this when we submitted comments on it. We said that this might lead to confusion and delays in providing the information. And the reason for that is not only would an opt-in be required, but prior to requesting information, the new payer is actually required to provide a confirmation of enrollment as well as an attestation of opt-in. As we know, anytime that there is going to need to be either a consent or an authorization or an opt-in, and that form's going to need to be provided, sometimes that just leads to this inevitable barrier when it comes to sharing information. So this might just be one thing that you want to keep an eye on in terms of this rule. And then continuing on with requirements, if an individual is covered by 2 payers or has that concurrent coverage, data exchange must occur to one another every quarter at a minimum. In addition, and kind of similar to the Provider Access API, payers are going to need to make certain educational information available to patients on opting in and instructions on how to opt in, as well as they're going to need to provide educational material to only those who have opted in annually. So this one's going to be a little bit less available just because it's only going to those that are opting in, and it might not need to be publicly available, although I'm sure that it could be. And then another note is that payer-to-payer exchange is meant to be a kind of one-time share for an individual switching plans, and then a quarterly share for the concurrent coverage, but it's not going to be continuous in between these 2 instances. And then I know there are a ton of requirements here, but this is kind of the last set. because for the most part, peer-to-peer exchange will involve that one-time sharing, patients do have this ability to request subsequent data if they choose for other situations. In terms of timelines, new payers must make their request no later than a week after the start of coverage, and then previous payers must make it available within 1 business day. There's a little bit of confusion when it comes to this portion of the rule. Hopefully, before it goes into a compliance period, we'll get a bit more clarity from CMS on some of these things, just because, you know, we know that patients are able to make requests a little bit later on, but then they do have some parameters that they need to stay within in terms of requests and turnaround times. So this will, again, will probably be something that we'll get a bit more clarity on moving forward. All right, and then I will just pause here before getting into TEFCA just to see if we had any specific questions on peer-to-peer exchange before moving on.
Yes, it looks like Eric asked in the chat. So the new payer would collect the opt-in and the previous payer would accept that and provide the data, as opposed to the previous payer collecting the permission to share with the new payer. Do you need me to read that one more time?
The previous payer would collect the opt-in, and the new payer would have the attestation or the conferment of the new enrollment. So it's kind of going to be the two payers would each have one aspect of it, but both forms are needed to be provided prior to the data transfer occurring.
And another question, does this go into effect in 2027?
Yes. So I think the proposed rule had the compliance period starting in 2026, and then when the rule was finalized, they pushed it out a year just because it did take some time for the final rule to come out.
All right, those were the only ones I'm seeing right now.
Okay.
You're
Sounds
doing
good.
so great,
And then,
Shreya. Thank you.
you're welcome. Glad to see you could join, Joanne. And then just for the final topic of the presentation today, I'm just going to delve into a few TEFCA updates. So as many of you may have been seeing perhaps through email updates or other forums, there have been many updates in the national interoperability space as it relates to TEFCA. They came out with a Common Agreement 2.0. They came out with an updated MiHIN technical framework, and then they also released a few additional standard operating procedures. So I was just going to bring a few key points to the forefront, just so that this group could be cognizant of them and kind of follow up if you had any additional questions. So just in a general sense, one thing that we noticed right off the bat with the recent update to the TEFCA Common Agreement 2.0 is that the main purpose for it was actually to allow for the ability for the TEFCA FHIR roadmap and for FHIR exchange to occur more seamlessly under that TEFCA framework. Although this isn't going to be a requirement under TEFCA, as we've just seen as I'm going through the CMS interoperability rule, there are many FHIR initiatives, particularly for payers, and they want that exchange to be able to occur under this kind of overarching framework. So they've kind of set up the legal agreement, the new technical framework, and some of the standard operating procedures so that this can occur for those who are ready to begin that exchange. The second thing was that they made a standard operating procedure related to the healthcare operations permitted purpose or exchange purpose. And while we are generally very supportive of this, we did submit feedback to the recognized coordinating entity or the RCE who's operationalizing TEFCA just to really understand what aspects of healthcare operations exchange is going to be permitted for. As a refresher, healthcare operations covers many different areas under HIPAA. It can be used for administrative, financial, legal, quality improvement activities of a covered entity that are just in a general sense necessary to run its business and kind of, support the core functions of treatment and payment. So because it's such a big bucket, what we're really looking for here is if there's going to be a separate standard operating procedure for each one of those categories, whether this is going to be compulsory or an optional a piece of exchange under the framework, and just kind of see how this is going to evolve over time. And then similarly, the next one is that they also released another standard operating procedure related to public health. Well, this one seems like it's focused more on the investigative aspects of public health sharing. We submitted feedback on clarity of how data governance would be leveraged here to allow for national public sharing when it comes to certain use cases. So obviously ECR, or electronic case reporting, is one that comes to mind, but we just wanted to know if it could be used for public health at large further on down the line, if that was something that was going to be on the roadmap, or if they would just kind of evolve that standard operating procedure over the years. More interestingly, they introduced two new terms that we hadn't heard prior, and they are the terms of principal and delegate, in which a delegate would be an entity that may need to receive or send information on behalf of a principal, and delegates can be connected to a wide range of principals that can fall across multiple QHINs, and this is going to be a new type of relationship that's allowable under the framework. So we're going to see, and the RC has also said that they see health information exchanges and health information networks like MiHIN functioning well as a delegate under the framework in the way that's laid out. I believe that they're going to follow up with a bit more information on exactly how this could work, but this is a kind of new, unique way to work HIEs into the TEFCA framework. The next change was the release of something called the terms of participation. This is kind of like a terms of conditions. And the reason that they released this is prior to making this change, they allowed QHINs to determine how they were going to flow down terms and requirements to their participants and sub-participants. And I believe that perhaps the feedback they were getting from QHINs is that this might lead to a fragmentation in language and maybe some misinterpretation across the various QHINs. So they just created a uniform document, which basically is going to apply to all participants and sub-participants that are active in the network. So this is actually going to be probably a very positive thing and quite straightforward. Although QHINs lose a little bit of the autonomy to craft that language themselves, I don't think that this is necessarily seen as a negative thing, but more so something that they were hoping to have. And then lastly, and most excitingly, the new updates to TEFCA will allow organizations to join more than one QHIN depending on the functionality that each QHIN offers it. So this is going to be positive because it makes sense for most stakeholders today just based on their relationships with certain entities that may be becoming a QHIN. Again, this is another area where they just released all of these. We did give verbal feedback. We also gave written feedback, but we're really just waiting for more information on this just because they were very worried about the way that organizations would be listed in the RCE directory and not having duplication. So we will see how that will kind of change as we move forward. So I think that we have about 12 minutes, and I did want to leave time for any questions that I might have missed or any questions that you may have thought of after the fact. So I think I'll just open it up to the larger group.
Well, first and foremost, thank you so much, Shreya. This was incredibly informative and helpful. So thank you, thank you. We did have one question already come in through the chat. Robin was asking if MiHIN is a QHIN.
We are not a QHIN. We do have a kind of national counterpart organization that is intending to apply, and we will certainly be a participant in the network and kind of support national interoperability as it kind of moves forward. But no, we are not a QHIN at this time.
Anyone else have any questions? Again, please feel free to use the chat or to come off mute. All right, I am not seeing anything. I think, Shreya, you did an amazing job. So you probably answered everybody's questions already, or just gave them a lot of information to think about and to do some digging into. We, as I put in the chat, we will be sharing these slides. You can find them anytime along with any past presentations and recordings on our website. I'll include a link in the chat for that once again. And I will also, if Shreya is open to it, I can include Shreya's contact information as well if you have any specific questions that you would like to reach out to her directly for. And Joanne was able to join for part of this. Joanne, do you want to give a shout out and say hello to everybody since they missed seeing your face this
Oh, yeah,
morning?
I'm sure. No, I just love, thank you. I said, thank you so much for coming. You know how to get to us. We will continue to provide these, this type of thought leadership, moving in and out sort of at the higher levels of this work and moving even deeply into our applications and our data exchange solutions. So thanks for attending and engaging. Thanks for working with us.
All right, wonderful. Well, yes, we will hopefully see you next month. We'll be sending out an invitation for the next download and the next topic. But if you have any questions in the meantime, please feel free to reach out to any of us. We are here to help. Have a great rest of your day, everyone. Bye-bye.